example, a statute that refers to a list of swords, knives, daggers, dirks, and pikes. There you look at that list of things and you say, aha, those are all weapons, therefore a pike is a spear, not a fish in that particular context. Now look at this list of verbs: block, prohibit, compel, direct, and so forth. You don't look at that naturally as an ordinary reader and say, oh look, they're all not revenue raising. What you say is, they're all very broad, powerful, actions that you can take.
The verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA, what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating importation.
No, I know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of the statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though trading with the enemy is happening is the president needs the authority to prevent trading with the you can't go over X percent, or it can't last more than 1 year. And of course, the way you interpret this statute, it has none of those constraints. And the question arises why it is that any president ever would look to the tariffs in Title 19 if, sub silentio, if you will, this statute gives the president the opportunity to blow past those limits.
The statute has its own constraints. Constraints that are appropriate in the context, which is internationally rising emergencies. They're carefully crafted by Congress to address that, and they are admittedly different. They're in Section 1701. The president has to make a formal declaration of a national emergency, which subjects him to particularly intensive oversight by Congress, repeated natural lapsing, repeated reports, and so forth. It says you have to consult with Congress to the maximum.
I mean, you yourself think that the declaration of emergency is unreviewable. And even if it's not unreviewable, it's of course the kind of determination that this court would grant considerable deference to the president on. So that doesn't seem like much of a constraint. And in fact, we've had cases recently which deals with the president's emergency powers, and it turns out we're in emergencies everything all the time about like half the world.
Well, this particular emergency is particularly existential, as Executive Order 14257 says. Of course, no one disputes the existential nature of the fentanyl crisis, which we had an agreement last week to create progress on, which illustrates the effectiveness of the deterrence tool. But the point I would make in response to that is those are, even if there's limited judicial review, which is very natural in the foreign affairs context, this court has always granted the president the presumption that he's acting in good faith. There are real hurdles there very significant. It's got to be a huge extraordinary threat that arises in a more substantial part outside the United States, which is entirely foreign facing to the national security, economy, or foreign policy of the United States. So there are those. Then there's 1701B, which talks about how it can be used for this and for no other purpose. Then there are limitations in Section 1702B. Then there's the limitation I referred to earlier about what it can actually do. You can do a heck of a lot, but only when it's dealing with property in which foreigners have an interest. And that's a pretty narrow domain. That's quite a sidebar, so to speak. And then, of course, overarching it all, there's congressional oversight. And they say congressional oversight can have much right. But Congress didn't think so. Congress crafted this compromise. It balanced the never-ending tension. When it drafted it, it had its eyes open, as the dissent below says, its eyes open, looking at the problem of sweeping emergency powers for an executive who may use them in a way that's excessive versus the need to address one question.
Thank you, General.
Justice Gorsuch. General, just a few questions following up on the major questions and discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit? May neglect the duties as he sees fit?
We don't assert that here. That would be a much harder case now. In 1790.
Isn't that the logic of your view,
I
though?
don't think so, because we're dealing with a statute that wasn't carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with I want to explain to me how you draw the line, because you said we shouldn't be concerned because this is foreign affairs, the president has inherent authority, and so delegation off the books. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war to the president?
We don't contend that you can do that.
Why not?
Well, because we're dealing with a statute again that has a whole
I'm not asking about the statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions and non-delegation, what might it would have in that case.
I would say by then you would move from an area where there's enormous deference to the president and actually both the political branches where either there's inherent authority and pile on top of that there's a broad
You're
delegation.
saying there's inherent authority in foreign affairs, all foreign affairs, so regulate commerce, duties, and tariffs and war. Inherent authority all the way down to fine. Congress decides tomorrow, well, we're tired of this legislative business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are means and bounds, so to speak. It could be a wholesale
You say
application.
we're not here to judge means and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something with more pipe. You're saying it's something less. What is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right approach is a very, very differential application of the intelligible principle test, and that sort of wholesale application.
All right, so now you're admitting that there is some delegation principle in play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential, limited is what, and again, the phrase that Justice Jackson uses just does not apply.
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think he would have, as our frontline position, is a stronger position, but the court doesn't accept it. And if there is a highly
Give me a reason to accept it, though. That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war?
well, we don't contend that. Again, that would
Well, you do. You say it's unreviewable, or there's no manageable standard, nothing to be done, and now you're. I think you. Tell me if I'm wrong. You backed off that position.
maybe that's fair to say.
Okay, all right.
That would be
Thank you.
an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that. All right, and I wanted to return to something that Justice Sotomayor asked under this statute. Okay, so now we're in the statute. It's major questions. Question: could the president impose a 50% tariff on gas-powered cars, auto parts, to deal with the unusual and extraordinary threat from abroad for climate change?
It's very likely that could be done. Very likely.
I think that has to be the logic.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a crisis, but
I'm sure you would.
but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime. There's a lot of your examples of regulating commerce, and your best one, Hamilton, for any civil war. They occur during wartime when the president's command-in-chief power is clearly in play. Does the president have inherent authority over tariffs at peacetime?
No, we do not contend that. And in fact, I cite, if I may, I point the court to two cases, Loving against United States and then Nazareth and cited Loving. Those are situations, for example, Loving against United States. The president had broad Article II inherent authority. There was the commander-in-chief power. But this court held he does not have inherent authority to do the power that was delegated to him, right? Which is the power to, identify aggravators that make you eligible for the death penalty and support partial trials. And yet this court said, we're not going to see a delegation problem here, even though it's really a wholesale delegation, which would otherwise be legislative authority. It would be kind of like a small version of what your hypothetical would be an application. Because you're in a foreign affairs context or they're commander-in-chief military context, the president has his own delegation of authority. He doesn't have the power to do this. Because of his background inherent authority, the court said, this is a situation where we're not going to see a delegation problem when there clearly would have been a delegation problem in the domestic context. In those cases, I think the problem
General, if I can cut through those words, I think you're saying that no, the president doesn't have inherent authority over tariffs in peacetime.
absolutely is. We do not assert that. We say that Congress can delegate that to him, and when Congress does so, as it does when you use the phrase regulated importation.
I follow all of that. Okay. You emphasize that Congress can always take back its powers. I've mentioned that a couple of times. But don't we have a serious retrieval problem here? Because once Congress delegates by a bare majority, the president signs, and of course every president will sign a law that gives him that authority. Congress can't take that back without a supermajority. And even then, it's going to be what president's ever going to give that power back? Pretty rare president. So how should that inform our view of delegations in major questions?
I would look at the balance that Congress struck, because what Congress did initially, it had a two-house legislative veto.
And we struck that down.
And then Congress went back to the statute and amended it. It took out the legislative veto and left it a joint resolution, but still left the president with all those functions.
That's what Congress did.
Yes.
Fair enough. As a practical matter, in the real world, you can never get that power back.
I disagree, because in January 2023, Congress voted to terminate one of the biggest IEP emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
What happens when the